Good day to you all. My name is Chuck Dick. I have the privilege of being one of the co-chairs of the programming committee for CalArb, and my distinct pleasure is to serve as a host for this series we call California Conversations. Today's a special day, one that I frankly have been looking forward to for a long time because I have the pleasure of introducing you to a person I've known for some 35 plus years. We go back a long ways into the days when we were both in big law and have both ourselves transitioned into the alternative dispute resolution world. And so, as a consequence, I'm really pleased to introduce to you today a friend of mine and a person that I find extremely interesting. There probably isn't anybody whose name comes to my mind quicker than Tom Hanrahan when I think of a particularly difficult, knotty issue. This is a guy who's got some background, some insights that are always worth listening to. And so, Tom Hanrahan, welcome to California Conversations. I'm really looking forward to spending some time with you today and letting our viewers around the globe here learn a little bit more about you.
Thank you. Thank you, Chuck. That's a tall billing that you've given me. We'll see if we can match the preview.
Well, a great way to start is to find out how in the world you ended up in law in the first place. I guarantee you, a person with your accent ain't no Californian by birth.
No. So here's a sort of quick version of the background. I grew up in New York, in Flushing, in Queens. If you're familiar with New York and the subway system, it was a 15-minute bus ride past the end of what was then the number 7 line in Flushing. Flushing at the time was almost entirely Irish, Italian, and Jewish. Today, it is largely Asian, Korean, Chinese, and neighborhoods change. But grew up there, although we were a stone's throw from then Shea Stadium, where the Mets played. I did have a chance to go to the 1969 Miracle Mets in the World Series. But I grew up as a Yankee fan. Went to high school in Manhattan at a Jesuit high school there, Regis High School, for those of you familiar with Jesuit education. It is, I'll give you a little plug for Regis. It's an all-scholarship school. It is the heart and soul of Jesuit secondary schools. Went from there to Fordham University for undergraduate work. And somebody asked me not long ago, how did you wind up going to law school at all? Because we didn't have any lawyers in the family, still don't. And I don't have a good answer for that, except that I had been on the debate team in high school, and it seemed like a logical progression. Going to law school bought you another 3 years before you actually had to do something with your life. So I wound up going to Columbia. While I was there, spent a summer in the homicide bureau of the Manhattan DA's office. And I thought it was just fascinating, absolutely fascinating. I do remember one of the early presentations by, I can't remember if he was the head of the bureau or the first assistant DA or something like that, but he gave us a little speech about how he prepared for trials. And he said the first thing he did after getting all the information from the police department and the detectives was he sat down and he wrote a closing argument. And Chuck, as a good trial lawyer, you will appreciate that. You kind of start at the end. Where do I want to end up? Where do I want this jury to come out? And how am I going to get them there? And work backwards from there. I thought that was fascinating. At Columbia, you get flooded with law firms in New York who are looking for new associates. I had offers from a number of those firms, but one firm came out from Chicago. It was the Kirkland and Ellis law firm. And they become much more successful since I left, I will say. But a fellow named Don Kempf came out for on-campus interviewing, and he was by far the best interviewer I had met. He was engaged. He was drawing maps of the city, talking about the city's culture and history, and importantly, the opportunities at the firm. And he said, we're just kick young lawyers out the door much faster than they do in New York. So we took a job. I took a job at Kirkland. My wife and I, Amy, got married about a week after law school graduation, packed the little bit that we had in a U-Haul truck and hightailed it out to Chicago. I will say that at Kirkland, within the first month that I was there, well, probably a little longer than that because you had to pass the bar first. So let's call it January, after the bar exam results came out. I was sitting in depositions with all of these senior partners from major New York law firms in what was then, I think, the largest price fixing case in history. It involved something called folding cartons. Think of cereal boxes, things like that. And I'm sitting there eagerly taking notes, and the rest of these guys are there doing crossword puzzles and reading the New York Times, things like that. And that was the experience that I had there. So wound up in Chicago and stayed there for 6, 7 years, I think, doing a lot of antitrust work. Started off in that folding carton case, moved on with many of the same clients to what became an even larger case involving corrugated containers, which involved a lot of law firms around the country, some terrific lawyers. The case was located in an MDL proceeding down in Texas, in Houston. Met some terrific lawyers down in Texas during that. Steve Sussman, whose name some of you may remember, was lead counsel for the private plaintiffs in those cases. An absolutely terrific lawyer. And one of those guys who, if he said he was going to do something, he would do it. You didn't need to put it in writing. He would do it. He didn't have much time for nonsense. And that's something I've remembered as I move into, my neutral career as well.
Well, I want to focus a little bit more on that experience you had at Kirkland. Obviously, as you say, they kicked you out the door very quickly on, which isn't necessarily the standard practice of big law.
Oh,
Uh,
Lord, no.
and you must have learned fairly early on some important lessons about what you liked and what you didn't like. And I'd be interested in you sharing that to our viewers.
I guess I came to, well, let me put it this way. When I started, I had this view, which I later concluded was not entirely correct, that there were deal lawyers who did their thing, and there were litigation lawyers and trial lawyers who did their thing, and those paths really didn't cross. Totally different skills, different knowledge-based requirements, and that sort of thing. And I liked the standing on your feet, this is going to sound pompous, center of attention sort of thing, but you're in control of the outcome, and there's an audience, and you win or lose. I came to think later on that really good trial lawyers understand the business side of their client's business and what their business objectives are. And we were doing all commercial cases for the most part. And they understand how the business process works. And it makes them better trial lawyers because they have a better idea of what the client needs, which may not be what they say, but what they really need. The really good deal lawyers, I think, understand where the risks and opportunities are on the litigation side of the world. The best pair of lawyers that I knew was a couple of my partners at Sidley in Los Angeles. One was primarily real estate finance practice, and the other was a trial lawyer, much like myself, but he worked primarily on real estate clients. And they would talk to each other constantly about deals that one was doing and cases that the other was handling on the litigation side. And I think they took this to heart. It made them both better lawyers at their particular practice niche and practice focus. So for the young lawyers out there who are wondering, should I care about the deal side of the world, the transaction side of the world? Absolutely. Learn as much about it as you can. It'll make you a better litigator.
Well, you ended up after what, 8 years or so with Kirkland in Chicago, migrating across the street to Sidley and Austin. How did that come about, and where did that take you in your next chapter of your
Yeah, not
professional
entirely
life?
across the street, but to give you the setting. So we were in Chicago. We had two young children at the time. When we moved out to Los Angeles, they were what, 4 and 2 or thereabouts, roughly in that neighborhood. So my family was all in New York. My wife's family, except for one brother, had all moved out to San Diego a couple of years earlier. So we're in Chicago. We had no family, no close family ties there. And there was a former Sidley associate who had moved to Sidley in Washington, who had called me one day and said, we've opened an office. He just said Sidley is looking for antitrust lawyers, as many as they can find, as fast as they can get them, because the firm at that time was deep into the AT&T divestiture cases, which you may remember. And there were hundreds of private antitrust cases floating around after the AT&T divested itself from local telephone business. And he put me in touch with a fellow named Ted Miller at Sidley in Chicago. Ted was then the number 2 guy on the Sidley sort of national AT&T litigation team of, I don't know, 200 plus lawyers. So Ted calls me and says, why don't you come on over and let's chat? What I later learned was Ted's style. I said, oh, come on over, we'll talk for 20 or 30 minutes. So I go over there and we talk for our 20, 30 minutes. And Ted then says, well, let's go see who else is around the office that we can talk to. And we kind of march around the office, totally unplanned, spontaneous, just looking for people to talk with. And he called me a week or so later and he said, would you consider going to Los Angeles? And with half the family, my wife's family in San Diego, that was not unattractive. went out to Los Angeles, where the office then had maybe 30 people. Most of them, the core of that office had come in through a merger with a bankruptcy firm in Los Angeles, headed by a guy named Ron Trost, who was then one of the half a dozen lead bankruptcy lawyers in the country. Ron was a bit of a force of nature. But I talked to virtually everybody in that office, and I came away with two conclusions. One was these folks were all smart and interesting people. And second, there were no jerks in the crowd. I might have used a different word, but no jerks in the crowd, which is kind of important if you're going to walk into a group that you don't know at all. It's nice to know that there aren't any people who are going to be truly challenging to work with, put it that way. Interestingly, I heard that from another lawyer later on when we get to the story, but we had brought in a group from a firm that was dissolving, led by a fellow named Stuart Caddison. And one of those lawyers told me years later why they decided to join Sidley instead of others. And he told me essentially the same thing. There were no jerks in the crowd. So we moved out to Los Angeles. I moved out, I guess a couple of months or so during the summer. I kind of went back to Chicago every couple of weeks or so. My wife was back in Chicago, expecting our third child. So we move out here, out to Los Angeles in, I think, around September or so. Second daughter is born in early November, if I remember right. And things kind of went from there. Just started practicing. I will tell you, one of the interesting things about that office was there was this group of about a dozen or so core people who'd come in with Ron Trost and his bankruptcy group. And the others were all laterals. So it was this environment where there was virtually no traditions, no customs built in, no ways of doing things that everybody had been living with for years. In terms of firm and office culture and practice, we kind of made it up as we went along, which made it a lot easier for everybody coming in. So that's how I wound up in Los Angeles.
Well, I'm very happy that you dropped the name of Stuart Caddison. Every
Yep.
time I put this tie around my neck, I think of Stuart Caddison, who's the one person who taught me it's perfectly appropriate to wear a bow tie and stand up in front of a jury or a judge. He said, you don't need to be worried about this. He said, everybody in the world knows that if you want to honor and dignify the event, you put on a bow tie and a tuxedo. So it's the people who don't wear bow ties that ought to be worried about their appearance. I've always remembered that. Stuart was a real character.
I'll tell you a quick Stewart story along with the bow tie. He also had, you may remember this. For those of you who didn't know Stewart, he was a terrifically talented trial lawyer, fellow of the American College of Trial Lawyers, as I recall. He had been president of the state bar, if memory serves correctly, one of the senior people in the Los Angeles and California legal community. He always wore a three-piece suit pretty much every day, and he always had this little carnation or exactly what flower it
It was
was.
baby orchid.
Baby orchid, exactly, in the little buttonhole on the lapel. And I asked him one day, why do you wear the flower every day? And he said, that's why. Kind of puzzled. I said, what? He said, you noticed. And you were curious. And when I'm trying cases, I want people to notice me and be curious about what I'm going to do next.
Well, Tom, you had a very successful stint with Sidley and Austin. You went on to become the chair of their commercial litigation practice, I think globally for the firm, which no doubt imposed upon you some managerial responsibilities and cut into your law practice time. I'd be interested in having you share any perspectives that you gained from your managerial stint and thoughts you might be able to share with our audience on that topic.
I'll give you a background on how this happened. We had a partner who's the practice group leader in each of the offices. And for the major practice areas, like commercial litigation, we had, I think there were four of us at one time who were sort of this ad hoc committee of global leaders for that practice, try to lend some focus and direction, and more than that, even coordination to it. So when I became head of our Los Angeles litigation group, which was, I don't know, 60 lawyers, give or take a little bit at the time, the first thing that one of my mentors there, who had had that role before I did, said to me, he said, people will see you differently now than they did yesterday. So, to the extent that you are quick to drop comments from the back bench that some people find amusing, that you're going to have to be careful what you say because people will hear it differently. And I looked at him and I said, why? And he said, because you have a new role and they think you have their professional prospects in your hands, which is not true. You know, the success that lawyers have, at least in law firms, can't speak to corporate or government roles at all. But at least in law firms, I suspect this is true whether the firm is very large or more modest size. The success that you have is dependent upon whether you are able to satisfy your clients. And satisfying your clients means in the first instance, you have to build some relationship with clients. And so my role, as I saw it, was put the lawyers in places where they can capitalize on opportunities that might come to me. You know, it might come to me by way of someone in another office saying, can you help out with this? Or can you take on this matter as the head of the group? Sometimes I would do it, but more often I would say, I got somebody who I think would be really terrific for that and push them to do it, particularly if they were younger partners. A large part of the role for senior people in a law firm is pushing things down and making sure that people who are in their mid 30s to mid 40s are getting the client relationship opportunities that they need to prosper during what is generally sort of peak career, mid 40s to late 50s, let's say. I saw my role as making sure that people were getting opportunities. That was one thing on the partner side. On the associate side of things, it was much more about mentoring. So checking in with them periodically to see, how are you doing? Let's go have a cup of coffee. Unplanned, spontaneous things. Give them some ideas, suggest, let me see if we can find you a chance to work with Sam or Mary or Bob or whoever. So they get some opportunities to do things. I will tell you, in my current role as arbitrator, and you see a whole lot of names when you look at the list of lawyers who are involved in a matter. And you'll hold a preliminary hearing, typically with the lead lawyers, not always, I will say, but typically. And I encourage them to find roles for the younger lawyers on your team, appear at hearings, argue motions, whatever it might be, examine witnesses at hearings, find roles and things for them to do, because that's how you learn. And so I saw a large part of my job is that. On the national front, it was really much more a matter of whether we are capitalizing on opportunities for clients whose business was spread across the country and often enough across the globe. You know, give you an example. We had a large food, drug, cosmetic practice, pharmaceuticals, medical devices, food industry, cosmetics industries. And I worked closely with a number of partners in Chicago and in New York on pharmaceutical matters, and worked closely with some partners in Chicago on a client in the cosmetics world who was based in Brussels. And so we talked regularly about how to manage that relationship, how to develop more business from them, other clients based in Brussels. And so I made trips over to Europe to talk to clients in both Brussels and in Germany. I didn't have the primary relationship, but I had a role to play in expanding and broadening that relationship. And that's what the kind of global co-chair role was intended to do.
Well, it's interesting to me, Tom. You started out in one of the principal firms, litigation firms particularly, doing antitrust work, big disputes, oftentimes involving some role for the government on the other side of the case. That's not the kind of work that normally would end up in arbitration, but arbitration gradually crept into your professional life. And tell us a little bit about how that happened and how you then migrated to the career that you have now.
Yeah, interesting. At some point, I don't know how far back this is, 25 years maybe, the Los Angeles Superior Court, there may have been other counties in the state as well, had a non-binding arbitration program. They also had a volunteer mediation program as well. And this probably came up through the LA County Bar Association. I started volunteering to do some of those non-binding arbitrations. We handled them like any other matter. You got to do your conflicts check and all that. And then we have a hearing. You get a conference room, parties come in, you have a hearing, which would last, say, half a day, maybe a little more, but typically about a half a day. Relatively modest sized cases, but you'd have a hearing. And you write a relatively short award, might be a page or two, and you go from there. And I started doing those, and I probably did 20 or 25 of those over the course of a few years. And it was just fascinating because it was, as an arbitrator, you take the same skill set, the knowledge base, the skill set, the ways of thinking about things that you had as a trial lawyer, but you focus it in a different direction. Instead of being an advocate, you're now trying to sort of weigh who's got the better of the argument here. I mean, often it's not terribly difficult, but sometimes it is. And I just thought that was really very interesting. So I did that for several years. They suspended the program at some point when they had budget problems. May have been in the 2007-8 timeframe, somewhere in there. But I'd done a number of those over that period. Flash forward to, I don't know, 2012, 13, 14, somewhere in there. And I was starting to think about whether I wanted to continue representing clients for another 5, 7, 8, 10 years or whatever, or do something else. And I went through this process. I've shared this story with others. I asked myself two questions. One, am I still having tons of fun doing this? And the answer to that question was not particularly. I don't think I'm learning anything particularly new on the skill side of the world. Mentoring younger lawyers is still fun and enjoyable. But on the client side, was that still fun? Not especially. As many of you will appreciate, the constant need for care and nurturing of clients and the development of new relationships is never ending. It's there all the time. And it's a distraction from the things that you really like to do, which is to debate, try cases, file motions, argue motions, things of that sort. Second question I asked myself was, did I see the practice changing in any significant way over the next 5 to 7 or 8 years? And the answer was probably not. And it was an environment where clients were far more cost sensitive. We were seeing increasing resistance to paying for the training, put it simply, the training of younger lawyers, practice on somebody else's case, not mine. And so there's much more time for demands of senior lawyers' attention to matters, which has its own stresses and conflicts for you. And then this was sort of a pivotal event, maybe. I went up to Pepperdine and took the class up there. It was a week-long course on mediating the litigated case. And I came back, and I'd done dozens and dozens of mediations over the course of years, but I came back with a completely different understanding of what good mediators are doing and why they are doing what they're doing and how they are doing it, how they approach the matters. And I thought, my Lord, this is something that all of our lawyers should appreciate and understand. And so I decided about 10 years ago to retire from Sidley and go to a kind of exclusively neutral practice. Somebody asked me, are you going to do this full time? And I said, gee, I hope not. I might do it exclusively, but I don't want to spend 60 hours a week doing this. And I haven't. But that's sort of what the build up to it was, and the decision to go in another direction.
Tom, you have been notably prominent in the ABA's dispute resolution
Yep.
section. And I'd welcome your comments about the value of becoming involved in organizations such as that section of the ABA, or as well, perhaps the Chartered Institute of Arbitrators, of which you are also a fellow.
Yeah, let me
Uh,
start with there if I can, Chuck. Some of you may know a fellow named Jim Riemann, who's based in Chicago and New York these days. Jim and I met 2015, 2016, somewhere in there, at what I think was a spring meeting for the ABA dispute resolution section. In my memory, it was up in Seattle, but I could be wrong about that. Jim and I got to talking, discovered we both had kind of common Chicago connections. And he said, so what are you doing? I said, well, I'm thinking about doing arbitration, mediation work, things like that. And Jim at the time, I think, was the president of the North American branch for the Chartered Institute. For those of you who don't know, it's based in London. It's this group of arbitrators from around the world, most of them in Europe and Asia, I will say, but a significant number in the US. He said, you should go to the Advanced Route to Fellowship course that the Chartered Institute does to certify arbitrators as fellows of the Chartered Institute. He said, it happened to be that year in Washington. You got to do some homework. There's work to do in advance. There's work to do while you're there. There's work to do afterwards. And I went there. I thought, well, all right, that sounds interesting. So, it was whatever the registration fee was, it was relatively modest. Spent a weekend in Washington. I did have to do some homework ahead of time, which involved writing at least part of an award. You got part of a record. So start writing. And that program covered everything from what's the law, particularly in the international arbitration field, what's the process look like, what are the rules, how do you handle things, ranging from scheduling to managing the lawyers to written and other forms of testimony, evidence, which in the international world is largely documentary until you get to a hearing. And I thought the faculty was fabulous. The discussion was fascinating, ways of thinking about things. And as much as that, the other people in the, call it the class, were thoughtful and creative and had perspectives on things that didn't occur to me. I had perspectives that didn't occur to them. And so you had this really vibrant, robust dialogue among people. And as part of the end of that, you actually had to write the other half of the award, as I remember it. And then there was an interview after that, and finally you get admitted to as a fellow in the Chartered Institute. I will say two things about the Chartered Institute. One is for those who know, it's a credential that actually means something. It's not you just sign your name and write a check. You actually have to do something to get that and demonstrate it. And the second thing is, as with all of these professional organizations, it is a fabulous way to network and to become known and to begin to develop a string of relationships that put you in position where people, particularly if they're looking for a chair of a panel, or you got to select a wing for a panel, or you're just looking for who's a good arbitrator that, I've met somewhere along the way, something puts you front of mind. And that was always sort of the mantra when you're thinking about developing business as a lawyer. Here's the ABA story, dispute resolution section story. The dispute resolution section has for a number of years put on an arbitration institute, which is a 2-day program, typically in the spring. I was at an ABA meeting, I don't remember where this was, and I went to an informal breakfast, as I recall, and Gary Benton happened to be there, and I think most of you will know Gary up in the Bay Area. Gary was then talking about a plan, proposal, or something of that sort to deal with with what was effectively non-consensual or arbitration or forced arbitration in consumer and employment cases. And he and I got to talking about that. We were going to draft a resolution to address those subjects. But he said to me, you ought to go to the ABA Arbitration Institute that the section runs, which happened to be in Philadelphia that year. So I said, okay. And he said, but you got to hurry because registration is going to close soon. So I went there, and I must have been active in comments, questions, observations from the floor. Dana Welch, who most of you will know, came up to me at the end of that, or toward the end of it. She said, you should be on the planning committee for this program next year. I don't remember where it was, but that's what she said. So, if you know Dana, you don't say no to Dana. I said, okay. And again, it was, first of all, you don't say no, right? That's what I was told young lawyers. If opportunities are presented to you, don't say no, okay? It may not come again. If you don't like it, you can find a way to gracefully ease out, but don't say no. So I did that, joined the planning committee. I don't remember whether I had a role in any of the programs for the following year, but did that. One thing led to another, and I wound up being the co-chair of that program for about 5 or 6 years thereafter, which was, as anyone who's done this will know, is both huge fun and a lot of work, candidly. But you do meet a huge number of really interesting people, talented folks, some of whom become really good friends. And you start chatting about all sorts of things involving your own practice, your own cases, your own business planning, life events. And you also learn things, candidly. And so it is helpful to, how do I build a resume as an arbitrator? Go speak at programs, write articles. How do I do that? Well, start by going to programs or talking to people who are in a position to ask for articles. Anybody, any group that publishes something is always looking for writers, and programs are always looking for speakers. If you are at all inclined to do that, do it. It's going to be all to the good. It's a little bit of work, but all good things require some effort.
Tom,
So wound up doing that. And as I said, I found it enormously helpful, both professionally and personally satisfying.
well, your comments caused me to ask about your conscious continued participation in the American Bar Association. I understand that when you and I started practicing law, it was sort of a given that you would join the ABA. That's no longer the standard or the norm, but you found it very valuable. And I think I'd like to give you an opportunity to emphasize again what has been the value to you and how you would commend it to and why you would commend it to our viewers today.
Yeah, to provide some perspective. When I started practicing at Kirkland and then at Sidley, law firms like that paid for bar association membership. They viewed it as a good investment for reasons good and sufficient to themselves. Over the years, that practice has changed. And at least my understanding is that firms, as a general matter, do not do that any longer. And so it puts much more of your professional development burden on the individual lawyer. And if you are a young lawyer or a not so young lawyer, and you're saying, well, how do I begin to develop a network of people who will think of me when the need arises? Uh, that's sort of goal number one, right? You don't get hired if nobody's ever heard of you. So how do you get known by somebody? And particularly in the, in the neutral world, the arbitration mediation world may be a little bit different, but certainly in the neutral world, it's largely a solo practice. And so you don't have partners and associates, you don't have a marketing team and all that good stuff to kind of help you out. JAMS and AAA will do a little bit of promotion as opportunities arise, but generally they're not out there putting an ad in the paper for Chuck Dick or Tom Hanrahan every other week to keep you in the public eye. So how do you do that? Bar associations generally, in my view, remain the best opportunity for that. It's the place to start. It's the ground floor of building networks with other professionals. And it's an opportunity to participate in things. And you may change your mind from time to time about what you're really interested in, what works for you. And so you take a group like the dispute resolution section or the litigation section. And those are the ones I'm most familiar with these days. Huge and ample opportunities to get involved in program planning and attending meetings, even if they're on Zoom. If they're in person, so much the better, but even via Zoom, just to chat with people, speak up during question and answer sessions, reach out to people afterwards. LinkedIn, I think, is viewed with increasing favor among professionals as a way to keep in touch with people, to share ideas and thoughts. Yeah, that was not true 10 years ago, but it's increasingly so now. Bar associations provide you with an opportunity to reach out to your peers, begin to develop your own reputation, which requires you to do something. You can't just go there and do nothing. You got to actually talk to people or write something or say something, participate, volunteer to do things. That's how you get known. I don't know any other way to do it, frankly. Bar associates from the national level on down to the local level.
Well, Tom, it obviously has worked for you. You have become very successful as an arbitrator and as a neutral now in this new era of your life. I'd be interested in having you share some comments about what you see as the future of dispute resolution and the role that arbitration is going to play in that, particularly, but not only domestic, but international commercial arbitration. You're a fellow of the College of Commercial Arbitrators, and share with us your thoughts about what the future holds for us.
And let me give you a number of thoughts, maybe not all coherent or in ecological order. But one thing that I have seen and you hear about constantly is this sort of sharing of best practices between the international arena and the domestic arena. I'll give you an example. As you know, in the international arena, the exchange of information before the evidentiary hearing is almost entirely documentary, and you may have a series of witness statements, written statements that will come, and maybe witness A does a 15-page statement, and then there's a response to that, and then there's a rebuttal to that, all by the same witness, right? And those witnesses may or may not testify live at the hearing, depending upon what everybody agrees to. I do think there is an increasing kind of cross-fertilization of that into the domestic practice, where the subject of doing testimony in writing comes up almost all the time, at least in commercial cases, and particularly where parties are not in the same city, which is often the case. One of the good things from the pandemic experience has been that we are able to do hearings on this platform. For example, you can have hearings with people who are 15,000 miles away from each other. I'll give you an example. My son and his family were living in Barcelona at the time. He was working there. And I had a hearing scheduled. One of the parties was back here in Los Angeles. The other was in Dubai. Okay. We all agreed that we would start this hearing. We do it via Zoom, and we would start at, as I recall, it was about 10 in the morning in Los Angeles, which was about 5 in the afternoon in Barcelona, where I was, and about, I don't know, 7 or 8 in the evening in Dubai. And everybody agreed to this. Okay, fine. I managed to connect my laptop to the large TV in the hotel room where I was. So I wasn't watching everybody on a tiny screen, which I was very proud of myself. We started the hearing and we went for, I don't know, 6 hours, 8 hours maybe. It got to be around 2 in the morning in Dubai. And I said, we're close to done. I said, do we want to kind of recess and pick this up tomorrow? And they all said, no, we're fine. We're fine. We do this all the time. I said, okay, all right. You could not have done that way 5 years ago. The notion that you've got to have arbitrators, witnesses traveling all over the place is increasingly unnecessary. That's one thing. Second thing, as I say, is the increasing focus on easier ways to provide evidence. And written testimony is one of those. It has its pluses and minuses. I think it is more work for lawyers. It is certainly easier for myself as an arbitrator. It's easier to read something and think about it than to hear it once, think while you're hearing it, and then go back and try to think about it again. It does have its risks, I will say. I've seen a case. I had a case where lawyers all agreed we're going to do all the direct testimony in writing, and they did. And for one of the parties, they had not thought through the implications of a few paragraphs in the declaration of a key witness. And that turned out to be very problematic for their side. So the lawyers got to be really careful about how they do this. And it comes back to the story earlier about starting at the end. What's my story going to be? And then fill in everything necessary for that. And nothing that's not necessary for that. So you still got to be a good lawyer, even if you're doing this in writing, maybe even better if you're doing it in writing because it has a permanence. I guess the other thing that I see is a couple of changes. I'm not sure how long the mass arbitration experience will persist. It's turned out to be challenging for claimants and defendants, I think. It's got some kinks to iron out. For anybody who's done one of those cases I did recently, it harkened, for me at least, it harkened back to practice in the mass tort world, which I did a lot of in the pharmaceutical arena, where you'd have a bellwether trial or 3 or 6 or whatever the number might be. And then you go settle the cases, but everybody knows you're going to settle them. And you're not going to try for 40 or 50 or 100 or 1,000 or 2,000 cases. I guess the other thing that I see where there's a need for change, candidly, is lawyers who grow up dealing with rules and procedures in court face a different scenario, a different playing field when you get into arbitration, where the opportunities to shape it are much, much broader than they are in a court litigation setting. You can change your agreement if you want. You can change the rules. You can change timetables. You can make it up as you go along if you like. You may get some pushback from arbitrators, but the old line is arbitration is a creature of contract. And like any contract, you can change it whenever you like. And so you'll see things like there's a demand for arbitration, and what you get in response, you see this in California from California lawyers. The demand fails to state a claim pursuant to CCP section 430, whatever. I read these things and I say, you guys haven't really gotten the message that just doesn't work here. It doesn't apply here. I think there are opportunities for lawyers to get much better at this, but much as we were talking earlier about how lawyers can learn to take advantage of opportunities to build their own network and their business development, they can also learn to be much better in the arbitration world by learning how to take advantage of the opportunities that the rules provide. The last thing I'll say is the elephant in the room, which you hear about constantly, is the evolving role of artificial intelligence. and give you a couple of examples. There are platforms out there now, one or two of which I've used, which are terrifically good for taking a brief and asking the AI platform to summarize it for me. Tell me what the key arguments are, the key cases that are cited. Terrifically good at that sort of thing. Taking briefs or a pair of briefs and saying, give me a timeline. Terrifically good at that. I haven't tried that with dumping exhibits into an AI platform and say, develop the story from these exhibits. That's sort of next on my list of things to experiment with. But I think you will find increasingly sophisticated AI platforms, which will help you look for holes in the evidence, not necessarily tell you how to weigh it, but here's the law, here's what seems to be missing from the evidence. Those are some of the things I see on the horizon.
Well, Tom, the time that we have spent here today has exceeded my expectations. I mean, this is going to be very interesting viewing for those who not only want to get to know you a little bit better, but who also want to have some idea about some practical suggestions of how to go about expanding a practice, charting a course into the future. And I can't thank you enough on behalf of California Arbitration for taking the time to be with us today, to share these thoughts with us. It's been a real pleasure to spend these moments with you, to learn at your knee once again, and to share the time with you. Thanks so much to Tom Hanrahan.
Appreciate it. Be well.